then we come to the process of the actual nomination. Nomination is what? Nomination is actually the process of offering oneself as a candidate for an elective office. So, a person may feel that he wants to contest an election, so he will file the nomination paper. There are certain prescribed qualifications, disqualifications, he must fulfill them. See, under the constitution, qualifications and disqualifications, they are two different concepts. We may normally say a person is qualified, then if he is not qualified we may say he is disqualified. That is not there. Lack of qualification under the constitution and the law is not disqualification. You will still say he is not qualified, we will not say he is disqualified, because qualifications are separately laid down, disqualifications are separately laid down in the constitution and in the law also. So, a person who wants to be a candidate, he should be qualified and at the same time he should not be disqualified. Both the things are there. Then about the qualifications and disqualifications, I propose to take it up a little later, because that is a slightly detailed subject. In the next portion I will take it up with you, because that also you must know what are the qualifications, what are the disqualifications. So, for the timing, a person who wants to be a candidate, he should be qualified and he should be not disqualified. Then here itself I may tell you what is the crucial date for determining whether a person is qualified or is not disqualified. That will be the date of scrutiny of nominations. I will, when we discuss with those things, but right now I may say the crucial date is the date of scrutiny of nominations. Then, because we are now mainly going to say something about the elections to the Lok Sabha and the state legislative assemblies. So, today also my talk with you will be basically confined to these two elections. I am not going to confuse you with the elections to the Rajya Sabha or with the Vidhan Parishads. So, you will see that the nomination paper has to be in a prescribed form. A person can't just come and give you some paper saying here is my nomination, you take it, I am offering myself as a candidate. No, it has to be in a prescribed form. So, for the Lok Sabha, the form which has been prescribed as a nomination paper is form 2A. Again form 2A, which is appended to the conduct of elections rules. And for the legislative assembly is form 2B. This form 2A and 2B I may just slightly give you some explanation. See, this form 2A and 2B, though they are separate forms, but more or less they are similar in content. These two forms have been divided into 6 parts. They are not just run on, but they have been divided into 6 parts. Part 1 is filled by a candidate who says that he has been set up by a recognized national or state party. Then form, because there is a provision for only one proposer there. Then form 2A and 2B. Second part is for those candidates who want to contest as independents or as candidates of the unrecognized parties, because they require 10 proposals. So, that has been provision has been made for 10 proposals in part 2. Then part 3 is some declarations, we will come to that one. Then 3A again is a declaration by him that he is not convicted or something. Then 4, 5, 6 are in fact for you, you have to give the decision on that day, on the date of scrutiny. Then there is a portion for acknowledgement, all those, and then you have to fill up certain things. When we come to that I will tell you about it. But here also I may just tell you one thing here itself, that though the form 2A and 2B have been divided into several parts, and part 1 is to be filled by a person who wants to contest as a recognized national party candidate, and the part 2 by a person who wants to contest as an independent or a candidate of a registered party which is not recognized. But Supreme Court has said that somebody may fill both the parts also. It is not necessary that if a person wants to contest as a candidate of a party thinking that the party may ultimately give him the ticket, but he does not want to take a chance and he wants to fight as an independent also if the party does not adopt him, then he can fill both the parts in the same nomination paper. He may do it separately, but he may do it in the same form also. He may fill the part 1, he may fill part 2 also, and the Supreme Court has said there is nothing wrong in that one. Then nomination papers, the language. Normally some people may like to fill it in English, others may not like to fill in English, and they may complete it in the official language of the state. So this can be accepted in both languages. Then another thing which you must keep in mind, that normally what we do, we for the facility of the candidates, we get the ballot these nomination papers printed centrally. The chief electoral officer gets the forms printed and then he supplies to all the returning officers. But it is not necessary, and you should not insist that you must give me the nomination paper only in that particular form which I have or my state has printed. Anybody is free to copy. They can cyclostyle it, they can themselves even privately print it, even they can just copy it in hand also, but it should be exact copy of the prescribed form. So you cannot insist, don't insist, no I will not accept this form. You have to take it and then decide whether this is an exact copy or not. Then the first question is, a candidate, how many proposers are needed for the nomination? As I just mentioned, recognized party needs only one proposer. So there are several parties in India which have been recognized as national parties, and some have been recognized as state parties. Others are all registered with us but not recognized. I think today we have nearly more than 900 parties registered with the Election Commission, and out of those 900 only 7 are recognized as national parties, and about 46 are the state parties. So these national parties 7 and the 46 state parties, they need only one proposer. Here I would like to make one thing more clear, that if a party is recognized as a national party, then it is recognized everywhere throughout India. But if a party is recognized as a state party, then it is recognized only in that state, not in the other states. So in the other states they will be treated as registered unrecognized parties. So if a particular party which is say recognized in Tamil Nadu, that party wants to set up candidates in say the adjoining Karnataka or Kerala or Andhra, where it is not recognized, then in that case that party will require 10 proposers there, not one. So that you kindly keep in mind. Then there are certain restrictions on the conduct of contesting elections on the government servants, but there is no restriction that a government servant cannot even propose the nomination of a candidate. If he so feels, he may do it, but our advice would be better avoid that one, because somebody may say that way you are disclosing your interest in a particular party or so, or a party candidate, but under the law there is no bar. Then previously, maybe in the other elections, say for president election, some seconders are needed, but for a Lok Sabha election or an assembly election, you do not require any seconder. only just proposers are needed, proposers 1 for the recognized party and 10 for the all others. Then one thing again I would like to make it clear here, which of course is not here. Proposer, every proposer, that is very important, you kindly keep a note that every proposer must be an elector in the same constituency from which the election is being held, from which the nomination paper is being filed. So, a proposer must be an elector in the electoral roll of the constituency from where the candidate is contesting, but this restriction does not apply to the candidates. Candidates may be registered somewhere else also in the adjoining constituency or maybe in another district also in the case of a assembly election, or even in a different state altogether in the case of a Lok Sabha election, but the proposer must be from the same constituency. Then there was some doubt as to what is the meaning of a recognized political party, and then somewhere even the Supreme Court, perhaps they were not properly shown that particular provision. They said there is no definition of a recognized party in the law, though the expression is used, but there is an explanation to section 52 which says that for the purpose of this 33 is the process of nominations and 38 is the process of preparing the list of contesting candidates. 52 is where a person, if a candidate dies and then we have to go for countermanding. So here they have said the recognized party means a party which has been recognized as a national or state party by the election commission under the election symbols reservation and allotment order 1968. We will talk about this symbols order later when we talk about the allotment of symbols. This is a very important order which you will have to study very carefully, because allotment of symbols will be wholly governed by the provisions of this, and then how the candidates are set up, all those things are provided in this particular symbols order. We will talk about this later. Then this of course I have already said that if a party is recognized in one state, it does not mean that it is recognized everywhere. So in the other state it will be only a unrecognized party and will be requiring 10 proposals. Let me explain here itself as to how a political party will be setting up a candidate in your constituency, because as I have said that a recognized national party will require only one proposal, but how will you know that he is a person who claims to be a candidate of a party? Actually he is a candidate set up by that party, and at the time of scrutiny, at the time of further proceedings, you will be required to decide whether he is to be treated as a party candidate or not. So for this, that order which I mentioned, election symbols reservation and allotment order 1968, that has been made by the election commission. You must keep a up to date copy of that order with you always, because you may have to refer to that order, and if you just keep an outdated copy, we may have made some changes which you may not be even aware, and then that any wrong decision may affect the whole process. So you always keep, and we also take special precaution to supply copies of the latest orders on the eve of every election, so that the returning officer gets it. So if you do not have it, you would ask the CEO and he will give you, and if CEO does not have it, he should ask us, we will give him. Then if you see that particular symbols order, there is a paragraph 13 that explains the procedure as to how a political party can set up a candidate. This will apply not only to the recognized parties but also to the unrecognized parties also, because unrecognized parties ultimately when they contest and when we calculate the votes polled by their candidates, we should know who are the candidates set up by that party. So the same procedure they also have to follow if they feel that this man should be treated as a candidate of our party. So there are basically 3 very special requirements under that para 13. Firstly, the candidate himself must say that I have been set up by this party, that is the first requirement. That requirement he has to fulfill by making a declaration in his nomination paper itself. As I said, in the nomination paper, the third part itself contains a declaration that I have been set up by this party in this election. So that will be the first requirement. Then merely a claim by the candidate is not enough, because there may be so many candidates who may be saying I have been set up by this party or that party. So the party also must say, yes, of all those people who are claiming to be our party candidate, he A or B is the only man who is our candidate. So for that they have to comply with 2 requirements. Firstly, they have every party has to intimate the chief electoral officer and also the returning officer in a form which is known as form A, that for your state we are authorizing some, say, state's president of that party as the person who will be telling you who is going to be our candidate in your constituency, in constituency A, in constituency B, in constituency. So they have to first intimate the authorized office bearer of the party, who in turn will be telling you in this particular constituency he is the candidate of this party. So that is known as form A. And then that particular person who has been authorized to intimate you the name of the party candidate in your constituency, he has to give you that intimation in another form which we call form B. In that form B, the authorized office bearer of the party will say in constituency number so and so he is our candidate, and he has to give the address and that some name and the address of the candidate. So that has to come from person who has been authorized in form A. Sometimes we have seen that a party says that in this particular state or in this particular group of districts, this particular gentleman, say maybe state president, he will be giving the intimation in form B. But then there may be some problem, and then the president himself may say, no, I do not approve that one, now I am saying this man will be our candidate. No, we will not go by that one. We will go by the authorization in form B given by the person whose name is mentioned in form A only. This is just like a bank account. If a party has a bank account and the specimen signatures of certain signatories or functionaries of that particular party have been given to the bank, then howsoever some high person may be there in that party, but if he signs a check, bank will not accept. So just like that one, that intimation to you in form B must come from the person who has been authorized by the party in form A. So this you have to keep in mind. Somewhere I have said, if I can give form A to a person, why can't I give straight away form B? No, there is a procedure. If you want to change that, then first you say this form A will not be acceptable from this gentleman, we are changing this authorization. Then you say who is going to be the authorized representative, then naturally we will take that. And then second requirement in this particular form A and B is that it must reach you by 3 p.m. on the last date for nominations, because you see 3 p.m. on the last date for nominations, the whole process comes to an end, the nomination process. So by the time the process of nomination comes to an end, by 3 p.m. on the last date, that form A and form B must be in your hands as the returning officer. Any paper coming after 3 p.m. we are not going to entertain from any party. Then in this case another thing may be there. Sometimes you have seen, and it is a very practical thing, party may first give form B to one man, then there is some what they may call some problems, or there may be some other bargaining, so they say okay we are changing this one, we are giving this authorization in form B to some other candidate. They can do that, but that should also be done by 3 p.m. on the last date, and again this form B must be signed by the same man who has been authorized in form A. So the cancellation should also be in form B by the same person. Sometime if you see that form B, we have added a paragraph saying that the authorization given earlier in favor of X is hereby rescinded, and now we are authorizing this gentleman Y as our party's candidate. So you will take that, but we have come across several cases where they just sign and they do not cancel the earlier one. So the difficulty is that you are now with two forms B signed by the same gentleman, and you do not know who is the man. So previously our instructions were that you treat everybody as an independent, but then that led to some problems, because there were 2-3 candidates each claiming and each giving the form B and each having only one proposer. So the returning officer, he went by our instructions, he rejected the nominations of all because they were not proposed by 10. So the Supreme Court said no, you should have given him some more time, because one man was saying you give me some more time, I will get the clarification from the party. So to overcome that problem, we have now added another paragraph 13A in the symbols order, where we have prescribed itself that in such a situation where you have 2 forms or 3 forms B and no one is cancelling others, so everyone is saying this man, this man, this man. So in that case what we have prescribed, and it is a notice to every party also now, that the man who has given you the nomination paper, not the form A or B, nomination paper first, he will be treated as the party candidate. So we are not going to say whether this form B was given to somebody subsequently or earlier, we are not going. Whosoever has come to you claiming that he is the party candidate, he has given you the nomination paper, and his form B is also there, we will treat him as the party candidate unless that has been cancelled. If there is a cancellation, that is a different matter, but where there is no cancellation and a confusion is there, so we will go only by the time of the receipt of the first nomination paper. Whosoever has come to you first, we will treat him as the party candidate. That we have now clarified. So this is what has to be done by the party. Again, just to recapitulate, candidate must say I am a candidate of the party, then party must fulfill these requirements of form A and B by 3 p.m. Then one thing you also please keep this in mind, we do not what they call accept an authorization in form A or B being sent by email or by fax or so, no, it must come in original and it should be signed in ink, because otherwise some people may just prepare some rubber stamps and then go on putting them. So we insist, and it is there in the part of that form itself, it is instruction is contained that it must be signed in ink by the signatory, and it should not be sent by fax or email or telegram. We will not accept that. It should be delivered in original to the RO. The law, of course, in paragraph 13 we have said that form B may need not go to the CEO, but form A, that who is the authorized office bearer for the party in the state, it should go to the CEO, but somewhere the CEO may not have received, the returning officer may have directly received. So we have given a liberal construction to this, saying that because the allotment is and the scrutiny is to be made by the RO, if RO has got form A and B in time, then that will be taken as a substantial compliance. So, this is what you have to keep in mind while deciding whether a person has been rightly, validly set up by a party. Then I would like to dwell something more on this form B. See, in form B there is a provision, it is in two parts. One part says that he is our approved candidate. So, X maybe they say he is our approved candidate, but thinking that there may be some problem with X, or maybe his nomination may not be accepted, or maybe some other problem. So, just to safeguard their interest, the party may say Y is our substitute candidate. So, Y's name may also be given in that particular form itself, but here if on the scrutiny of nominations you feel or you find that X nomination is okay, then substitute candidate nomination on that form V will have no meaning. And supposing the substitute candidate has only filed one nomination or 4 nominations giving only one proposer, and he is not a candidate of the recognized party, then his nomination itself will be invalid. But if he has taken the precaution and has also filed another nomination, or in the same nomination he has filled part 2 also with 10 proposers, so in that case you will independently scrutinize that second part, and if there are 10 proposers then you will take him as an independent candidate. So, that substitute candidate will come as an independent candidate, but then there is one technical problem here that you must keep in mind. Supposing on the date of scrutiny you have accepted X, who was given by the party as the first candidate, you have accepted his nomination. Y you have not regarded as a candidate of the party, but because he had filed 10 proposals, so he is still in the race, he is an independent candidate. Now after the scrutiny there may be some problem or bargaining, the X says okay I am withdrawing. So, X can withdraw at any time within that period. So, in that situation our instructions and the rules provide that the Y whose name was given as the substitute candidate, he will step into the shoes of X, provided he is already there. Supposing the nomination of Y has already been rejected because he had only given a nomination with one proposer, so that nomination will not be revived. But if he is already in the race as an independent, then only the change from independent to a recognized party candidate we will permit, if his name is already there in form B as a substitute candidate. This you have to very carefully keep in mind. Some situation arose in Karnataka very recently. Somebody had given this form, this party had given X and Y as the main and the substitute candidate, but X and Y both had given only nominations with one proposer. So, X nomination was accepted, Y's this nomination was rejected, he was no more in the race, but then X withdrew. Then now the party wanted us that you please accept Y as our candidate. We said sorry, we can't do that. If he was there in the race we could have given you that facility of taking him from independent to the national or a state party candidate, but he is no more there in the race, his nomination has been rejected because he did not take that precaution, so we can't permit. So, this change from independent to in recognized party candidate will be permissible only if he is already a candidate. That I have already explained, that where a situation may arise where a same man may be having same party may be having more than 2, then this change also cancellation must be received by 3 p.m. And this also I have told you that a person in the same nomination paper may fill the first form, first part saying I am set up by this party, then he may fill the second part also saying that I am a independent with 10 proposals. So that is also permissible, and that also I explained that if a person has given you the nomination both as a party candidate and also as an independent, if the first part has been rejected, then you will not reject his whole nomination paper, you will see whether he has 10 proposals, and if he has 10 proposals then you will accept him as a independent candidate. Then next question is, how many nomination papers can be filed by a candidate? The law says that section 33 itself says that a person can file maximum of 4 nomination papers, and the law also says that returning officer shall also not accept more than 4. But supposing by some say confusion, or RO was sitting on one day, the ARO was sitting on some other day, somebody has given you the 5th also, so the first 4 only will be treated as having been received properly, the 5th you will not even scrutinize, you will simply straight away reject. Then the next question is, from how many constituencies one can contest an election, can file the nomination. Previously say there was no restriction at all, a person could file nomination in any number of constituencies. Now of course there is a restriction that it can't be from more than 2 constituencies, at a general election to the Lok Sabha or to the general election to the Legislative Assembly. If a person files from more than 2, then 3rd and 4th will be rejected straight away. 1st and 2nd only in the first 2 constituencies alone. Previously there was no restriction on the number of constituencies from which a candidate could contest election. There were some cases even people may be contesting elections from 40, 50 constituencies. There was one gentleman, with God's grace he is no more there. So he used to contest election from every constituency from where a particular important leader was contesting. He would go in a Lok Sabha election, he would go to all parts of the country, and at that time unfortunately the law was that if a person dies, if a candidate dies, the election would be countermanded in that constituency, whether he was an independent or whether he was a state party. So we were all keeping our fingers crossed, this man must survive, otherwise this election in very large number of constituencies will be countermanded. And those important leaders, they took extra precaution to see that no harm comes to this man. So now the law has changed. So at present a person can contest election only from 2 constituencies, in the Lok Sabha general election and 2 constituencies in the state legislative assembly. But supposing in a particular state the elections to the Lok Sabha and assembly are being held simultaneously, then it will be 2 plus 2. 2 constituencies he can contest Lok Sabha, 2 constituencies he can contest, because these are 2 different separate elections, and the 3rd and 4th nominations will be not valid. So this is the law, and same applies to by elections also, but by elections simultaneously means all, if a number of by elections to a particular assembly have been all simultaneously issued on the notified on the same day, then this particular restriction applies. Then the authority before whom a nomination paper can be filed. The nomination paper can be filed only before the returning officer or before the authorized assistant returning officer who has been specified in the public notice. Nobody else can receive a nomination paper. If somebody gives a nomination paper to any other officer or any other person working in the office of the RO, that will not be treated as a nomination paper having validly present. Then period, time and place. I have told you in the Election Commission's notification itself, the days will be specified during which the nomination papers can be filed. In fact, the total period is 8 days, including the date on which the notification is issued, but in between invariably there will be at least one Sunday. If no other public holiday, at least one Sunday will definitely be there. On a Sunday you cannot receive the nomination papers, no one can give the nomination papers. So the nomination papers can be received and can be delivered only during that period which is specified in the Election Commission's notification. Then nomination can't be given at any time. Supposing say 3rd January is one of the dates on which the nominations can be filed, but 3rd January does not mean right from the early hours to till late. The law section 33 itself says the nomination papers can be filed only between 11 AM and 3 PM, not before 11, not after 3 PM. So these are the time limits specified by the law itself, and then it can be only at the place which you have specified. Supposing you are just going down the corridor of your collectorate, somebody says please take this, you can't do that. You have to take this nomination paper only in your chamber which you have specified as the place, because we are going to keep a video record of videography of the entire nomination process. Sometimes difficulty arises. Some people may say I came to you at 2:50, you were saying you came only at 3:05. So the videography will help, and we will advise you that you go for the entire this process of nominations by videography. Here I would like to give you one more instruction. Particularly you have seen, the experience shows that on the last date there is a sudden rush. Many people come because sometimes the parties also take very late decisions, and then everyone starts running to the RO's office with his papers. On the last day there is very large rush, and particularly during the last hours also, and on many occasions the disputes arise. Somebody will say no, I came here at 2:30, somebody will say no, he came at 3:05 only. Then somebody may even make an allegation that the RO was very slow, and he or she was just very slowly accepting the nomination papers to see that our turn comes at after 3 PM, so that may not be received. So all these problems arise. So our instructions, particularly of course we would like you to have a video recording of the complete process from day 1 to the 8th day. Here on that day you have to be very particular. So our instructions are here on the particularly the last day are that about say 10 minutes before 3 to at 2:50 or so, you may say no, or you may make a public announcement outside or through some this loudspeaker or something that now it is 2:50, no nominations will be accepted after 3 PM. Then whosoever wants to file, they must come within your office chamber before 3, by 3, latest by 3, and whosoever is there in that chamber, we will treat them as having come by 3. So for that purpose you can even say from 2:50 or 2:45 or even 2:30, you can even start distributing chits through your AROs or somebody to the candidates, so numbered chits, so that one by one you may go on collecting and then taking their nomination papers. So immediately after 3, whosoever is there, you will treat as having he has come in time, and even if the actual receipt of the nomination paper by you may be taking some extra time, but on the nomination paper you must say received at 3 PM on that particular day, because everybody you can't, if 10 people are there inside your courtroom, you cannot accept all the 10. So immediately you as and when the papers are given to you, you go on noting 3 p.m. 3 p.m. so that nobody may tomorrow say that this nomination how could you accept in law, because 3 p.m. was the deadline. So this is our instruction, and 3 p.m. means the person who is inside with all papers, somebody may be there and thinking that my nomination paper is coming or my form A and B are coming. So I am here with nomination paper, but form A and B are there just on the way. Whatever paper is inside your room, that alone you will accept. Somebody has come to you with the nomination papers and he has all other papers, but form A and B is not there, and by the time his turn comes to present his papers to you, form A and B have also been received outside the closed room, you will not permit that form A and B to come now. Whatever is inside, whosoever is inside, he can present those papers only, not any paper from outside, and keep this please totally videographed, because otherwise so many allegations are made, and it is in your interest, it is in our interest that the in case of any problem, even this may be challenged in the election petition also, then we can also show that this is just the evidence that this man or this man was not having this paper, or this man came before 3, so we have validly accepted. So please, this is what we would like to do. Then the next question is, who can present a nomination paper? A nomination paper can be presented only by the candidate himself or by any of his proposers, no third person. A candidate himself comes, no problem, but he can send it through his proposer also. He cannot authorize somebody else that you please go and give it to no, but only the proposer, and proposer here will mean the proposer whose name is there in that particular nomination paper. Supposing he has sent 4 nomination papers and his name is only on one, proposer's name is only on the one nomination paper, so he cannot present the other 3 because he is not a proposer in that one. So the candidate can come with all 4, but if he sends through the proposer, then in that case all the every proposer must individually come, or supposing he has 10 proposers and his name is there on all the 4, then of course he will be a proposer. So this is what you have to keep in mind. Then this can't be received by fax or email or by post or anything, it has to be presented to you in person. Then naturally it has to be signed by the candidate and it has to be signed by the proposers, and in the case of the person who is not able to put his signature, maybe some illiterate man, normally nowadays that is not there, but in some remote areas some illiterate persons may also be proposing, so they have a problem. The law says that simply the putting of a thumb impression by the illiterate person is not enough, that thumb impression must be put in your presence, that is the difficulty. So that if somebody has come with a nomination paper with some thumb impressions and they are not put before you, then they are in law they will not be deemed to have been signed by the proposers. So signature is okay, but thumb impression in your presence and you have to attest, yes, it has been placed in my presence. Then another problem arises, particularly at the time of big leaders. So they would come with large processions and everybody would like to be inside the courtroom to show that yeah, we have come with you for filing your nomination, and so lot of difficulties were being experienced. So the election commission has given an instruction that in future, even now for the last several elections we are insisting, only 4 persons will be permitted inside the chamber where the returning officer is accepting the nomination papers. 4 persons we have said, the candidate himself, then he can bring any of other 3 persons, maybe some leader he wants, some proposer he wants, somebody else he wants, but he can bring only 3 more persons and the candidate. If the candidate is not there, then only 3 persons. Candidate can't be substituted by another person saying because candidate is not here, so 3 plus 1 more, no, in that case only 3. Then you have also seen they come in large processions of hundreds of cars and they are coming and then blocking all the ways, and so we have said that if somebody wants to come with a large procession of cars, you stop that cavalcade or carcade 100 meters beyond the office of the RO. If somebody is not willing to walk from that particular place, only 3 vehicles should be allowed within the premises or complex of the RO's office, and then not more than 3. And this you have to ensure, you have to appoint some nodal officer to ensure that this thing is strictly enforced, because we have taken some very serious view with regard to these matters in the recent elections, where some so called important leaders went with large number of persons and they were very happy to show their faces on the TV and all that. So we have taken some action against the RO also. So please be strict about this commission's instruction. Then the next step, which is very essential, is that the candidate must make a security deposit. Simply filing of nomination is not enough. Every candidate has to make a security deposit. Amount of security deposit is 10,000 in the case of Lok Sabha and 5,000 in the case of the state assembly. But where a candidate belongs to an SC or a ST, the amount is half. So 5,000 in the case of Lok Sabha, 2,500 in the case of the assembly election, and this particular facility is available to that candidate not only in the constituencies reserved for the SCs or SCs. Even in a general constituency, if an SC or ST candidate is there, he can avail of this facility of half deposit. Then this security deposit can be made in cash with the returning officer. Mostly in most cases you will find that this is the convenient method, otherwise they will have to go to the reserve bank or a government treasury with some challan, and then that is a cumbersome process. So almost every body nowadays is making this deposit in cash. So for that you have to appoint a particular person who should be authorized to receive this cash and give the receipts, but you should have a very responsible man, because it is a question of handling money, and our advice would be that you go on depositing this money every day with the government treasury whatever you receive. Otherwise if somebody is keeping that money with him for a number of days and a huge amount is collected, then he may not come and say, madam, I have lost my whole thing. So be sure that you appoint a responsible man and he goes on depositing the money in the treasury almost every day. One thing, supposing a man is filing 4 nomination papers, he is required to make only 1 deposit, not that for every nomination paper he has to make a separate deposit. So with the first nomination paper he can annex the original receipt. If he wants, he can take photocopies and then annex to his other nominations, but that is not necessary because the original is with you. So only 1 is needed. But supposing he is contesting from the Lok Sabha and also from the assembly, then in that case he has to make separate deposits. Similarly, if he is contesting from more than 1 constituency, he has to make separate deposits in each of those constituencies. So in 1 constituency 1 deposit. Then this is another very important requirement for a valid nomination. Previously there was no requirement that a candidate should declare anything with regard to his criminal antecedents or assets or liabilities or his educational qualifications. There is a long drawn history. Ultimately Supreme Court has decided in 2003 that every candidate who wants to contest election, he must tell the electors that this is my past, these are my assets, these are my liabilities, this is my educational qualifications, so that a candidate, the elector can make an informed choice. So, in pursuance of that Supreme Court's decision, which is we quoted here, the Election Commission has prescribed an affidavit. In that affidavit, he has to give you all the required information, and in addition there is another affidavit which has been prescribed in the conduct of elections rules, that is form 26. So, each candidate has to give two affidavits, one in form 26, another supplementing some information which is not in form 26 in the Election Commission's notification about the past convictions and pending cases. One thing I would like to make very clear to you, Supreme Court has very clearly said that if somebody does not file this particular affidavits, then he is disobeying our law, our instruction, I mean Supreme Court's direction. So, that will be a ground for rejection of the nomination. But somebody has filed these affidavits, and in those affidavits he has given some information which the others may say no, this is not correct, this is wrong, he has suppressed this information, he has say 5 bungalows, he is showing only 1 bungalow, he has got so many assets but he is showing only 1 savings deposit in a bank. So, those are not the grounds for rejection. Any wrong information or any suppression of information is not a ground for rejection of nomination by you. The only ground for rejection of a nomination paper is if he has not filed the affidavits at all, because at that time you cannot go into the question of the correctness of, somebody may say I have this house and its value is 10 lakhs, the other may say no, value has gone, now it is 50 lakhs. So, you cannot decide. So, the Supreme Court has said no, this question will not be gone into by the returning officer. The returning officer only must see whether the affidavit is there or not. But it is not the end of the matter. If supposing somebody says that the affidavit is wrong, we will say okay, we will take it up later. After the elections we may go into those questions, and if we find something is there, then we may take action against the person concerned for filing a false declaration or affidavit before the RO, that is a different issue. But it will not be a ground for rejection of the nomination. And our instructions are that in case somebody has not filed with the first nomination paper or the second, then as a precaution we have prescribed a letter also, that you give a letter to whosoever is there, the candidate or the proposer, that you have not given these affidavits, you have to give this affidavit to remind them. And these affidavits must be also received by 3 p.m. on the last date for nominations, not afterwards. Previously we had given on this instruction that it may be given later also till the time of scrutiny, but we have revised it in view of a particular decision given by the Madras High Court, and so we have made it 3 p.m. on the last date for nominations. And there are also instructions as to how you have to disseminate. You have to immediately give copies of these affidavits to everybody, whosoever wants. Do not charge anything, because there are several NGOs, there are several newspapers, there are several news channels who are now interested in this study. They may be giving information, and you have to display a copy on your this notice board. Then you have to give copies to your district election officer, and through him it will be put on the website. Whosoever wants to have an access, they will be doing it. And then we have said that if somebody wants to have it, say centrally from a district election officer, then it will not be free, then they will have to make the payment. But if somebody goes to the returning officer, then it will be given free of any charges. Secondly, we have also said that supposing that example I gave you, that somebody says this affidavit is wrong, he has suppressed this information, you say okay, whatever you have to say, you give me that affidavit. That affidavit also you disseminate, so that the people know that this man has said this, there are other people who are saying that this is wrong and this is the correct position, so that people come to know of both the views. So this is what we have to do with regard to these affidavits. Then if these are the things, if these things have been done, then naturally you will feel that the nomination will go through the first process. You will see must be qualified, must not be disqualified, that I will explain later as to what are the qualifications, what are the disqualifications. Then the nomination must be in the prescribed form, it can't be in any other form. There must be subscribed by the requisite number of proposals, 1 in the case of the recognized party, 10 in other cases, signed both by the candidate and each of the proposals. There is a space meant for the signatures of everybody, it should be signed in those places. Then security deposit he has made and he has to enclose that with the nomination paper, then he must also be complete. Then supposing somebody says I am a SC or ST, so simply a claim by me he will not satisfy you. If he is particularly where he is contesting an election from a reserved constituency, you have to be satisfied that yes, he is a scheduled caste or he is a scheduled tribe, and for that you can insist upon a certificate from the competent authority. And where in a general constituency he claims the concession in the deposit, there also you must be satisfied. Then here one more thing which is a very important requirement. If a person is contesting election from the same constituency in which he is a voter, then the electoral roll is with you, you can always verify whether his name is there or not. So he need not submit any other document to prove his registration as an elector. But if he is contesting election from another constituency and his name is registered in some different constituency, then the law says that he must show to you that he is a registered elector, and the manner in which he can show it, either he has to produce the whole copy of the electoral roll, which normally is not done, or a relevant part in which his name is there, but generally they will do a certified extract of the entry relating to his name in the electoral roll. The electoral roll here will mean the latest, which is current roll, not in the earlier roll. Earlier roll his name may be there, but in the current roll his name may not be there. So he has to give you the certified extract from the current electoral roll, and then current electoral roll, the time for presentation is either he should give along with his nomination paper or at any subsequent stage, and the law says, section 33 says that even at the time of the scrutiny of nominations also he can produce. So here he can go even beyond 3 p.m. on the last date nominations, he can go up to the time of the scrutiny of your nominations. So this is what he must do. Then there is another requirement which we will come on to when we talk about the disqualifications. If a person has been dismissed from the government service within 5 years, because disqualification for a government government servant applies for 5 years. So if within 5 years he has been dismissed, then he has to give you a certificate from the election commission, and unless that certificate is there with the nomination paper, he will not be taken as a validly nominated candidate, because the disqualification for dismissal is only 2 counts: disloyalty to the government and corruption. And so he says, oh, I was dismissed but not for the disloyalty or for corruption, I was for some other reason, I may have been absent or so something. So he has to come to the election commission for a certificate that I was not disqualified for disloyalty or corruption, and that certificate he has to give with the nomination paper. The law says that if that certificate is not there, then straight away it will not be taken as a valid nomination. Then I have told you about the 2 affidavits which he has to give about the pending cases, about the convictions, and then about his assets, liabilities. One thing more here, I will just tell you, this assets, the Supreme Court says, should be not merely of the candidate himself, but the assets of his spouse and also the dependent children. Whereas in the case of liabilities they have not said, liabilities only the personal liabilities, but the assets, his own assets, his spouse assets and also of the dependent children. Then naturally I have told you it has to be only between 11 and 3 p.m, not beyond, not earlier. Then this is another very important this qualification. This is about the oath. About this also I will tell you when we talk to, because every candidate must make an oath or affirmation. For that there is a form set out, and I will explain in detail about this oath when we talk about the qualifications in the later part of the talk. Then this I have told you about this form A and B. If the party accepts him, adopts him as a candidate, then those requirements must be met. Then if all these things are done, then naturally he can expect that he will be a candidate, and most probably his nomination will be accepted by the RO. So I think we will know. One thing more, we have not come to the end of this process. You have every day you have to give the notice of nominations which you have received. At 3 p.m. the process for nominations will end every day. So you have to give notice at the end of that day how many nominations you have received on that particular day, because people should know that these are the candidates now who want to, these are the persons who want to be in the electoral field, and they may be making their own decisions whether anybody else should come or not. So every day you have to give a public notice of the nominations received by you. That public notice is given in form 3A in the case of this parliamentary and assembly elections. You forget about 3B and 3C because we are not talking about the other elections. So 3A is a form prescribed name of the candidate, name of the proposers, then party affiliation if he claims to be set up by any party, address, etc. Those columns you have to fill and display it on your notice board every day. And in that you have, as and when you receive a nomination paper, you must go on giving serial number to every nomination paper. As soon as a nomination paper is received by you, you start with serial number 1 and then go on giving run on. Supposing on the first day you have received 5 nomination papers, on the second day you do not start with again 1, you start with 6, so that you know at the end of the 8th day how many nomination papers in all you have received. This way you will be ensuring that no nomination paper has gone astray. Otherwise if you say some nomination papers 5, 6, then ultimately you may not be knowing how many nominations are there, and this actually happened in one constituency. Even one of the nomination papers was lost in this process. It came to light only after the withdrawal, when he says where is my symbol. When he say, but you didn't file your nomination, he says no, this is my receipt. So you please be very sure every nomination paper has to be given a serial number. And then 2 more things which I would like to stress here. As soon as you receive the nomination paper, you have to give a serial number, and at the same time you have to give the precise date and precise time of your receipt. Supposing you have received some nomination paper say on 3rd January at 1 p.m. and 3 minutes. So you say 1 minute, 1 p.m, 3 minutes also you say, because this will become very relevant. Supposing a question arises, who was the man who first delivered your nomination paper, to decide whether he is X is the party candidate or Y the party candidate, then you will be going by that record. that he is the man who came on 3rd January at 1 p.m. and 3 minutes, and the other man came at 2 p.m. So you will have to decide. So this particular time is very important, immediately give. And then third thing more you have to say, because I have told you the nomination papers, they can be presented either by the candidate or by the proposer. So in the nomination paper itself there is a provision that you score off whether the candidate presented or the proposer presented. So if the candidate presented, there is no problem, you know who presented, but in the case of the proposer you do not know which of the proposers. So in the case of proposer you also additionally write the name of the proposer who presented that particular nomination paper to you, so that there is no confusion at the end. Thanks. So we are coming now to an end of the first this talk. Later on we will talk about the scrutiny and then qualifications.